Everybody, this is Ace with Conspiracy Realists, and today we're going to be talking about the basic criminal law versus the law of armed conflict. I found this thread through War Nurse on Twitter. I'm going to go with she, I don't really know if it's a man or a woman, has some pretty amazing threads on here. She goes really deep into things that we don't normally talk about. It's not mainstream in the movement, so to speak. I found this transcription between Lindsey Graham and Brett Kavanaugh during the Kavanaugh confirmation hearing. And she says, which I believe, that this will be an exchange that will be key in the coming years of revelations, prosecutions, and executions. Now, the reason I bring this up today and the reason I decided to make a video about this is because I believe that what's going on in our country, the insurgency with ANTIFA and BLM, is actually being looked at as a war. Right now, some of us call it the shadow war, some of us call it an insurgency, like I had just said. But in reality, they're looking at these people that are attacking cops, they're attacking federal buildings, that are hurting, killing, maiming peaceful protesters. They're looking at them as potentially enemy combatants. And so the law that an enemy combatant has against them is much different than the law of civilians, the law that we ourselves follow. And so this exchange has been this exchange was very pertinent to what's happening right now and what's to come in the future. And I just wanted to share this with you all today. So Graham begins by asking Kavanaugh, when somebody says post 9/11 that we've been at war and it's called the war on terrorism, do you generally agree with that concept? And Kavanaugh replies as, I do, Senator, because Congress passed the Authorization for Use of Military Force, which is still in effect, and that was passed, of course, on September 14th, 2001, 3 days later. I actually pulled that act up, and it states that whereas on September 11th, 2001, acts of treacherous violence were committed against the United States and its citizens, whereas such acts render it both necessary and appropriate that the United States exercise its rights to self-defense and to protect the United States citizens both at home and abroad. And basically, I wanted to just really quickly get to this part, was Section 2, the Authorization for Use of the United States Armed Forces, means in general that the President is authorized to use all necessary and appropriate force against those nations, organizations, or persons he determines planned, authorized, committed, or aided the terrorist attacks that occurred on September 11, 2001, or harbored such organizations or persons in order to prevent any future acts of international terrorism against the United States by such nations, organizations, or persons. And what I wanted to highlight about this is because this act has been enforced and in play since September 11th, 2001, they are still considering people as terrorists against the United States. And any nations, organizations, or persons that they deem to be terrorists they deem to be at war with, and therefore the law changes from civil law to the law of armed conflict. And that's going further into what this exchange is talking about. Graham then goes on to talk about, let's talk about the law in war. Is there a body of law called the law of armed conflict? And Kavanaugh retorts, there is such a body, Senator. Graham goes, is there a body of law that's called basic criminal law? Kavanaugh responds with yes. Graham then goes on to ask, are there differences between those two bodies of law? And of course, Kavanaugh then says yes. Graham then asks the next question. From an American citizen's point of view, do your constitutional rights follow you if you're in Paris? Does the Fourth Amendment protect you as an American from your own government? And Kavanaugh replies with, from your own government. Yes, it does. Not specifically from the French government, but if you are in France and your government accuses you of something, you still have the rights as an American to defend yourself with. So if you're in Afghanistan, do your constitutional rights protect you against your own government, says Graham. And Kavanaugh responds in the affirmative, saying rights as against the U.S. government. You're an American in Afghanistan. You have constitutional rights as against the U.S. government. And there's a long-standing, been a long-settled law that it goes back to a specific case. It's called Johnson versus Eisentrager. She linked this article explaining this case that happened in May of 1945. Germany surrendered to the Allies. Yet some German soldiers in China continued to fight alongside the Japanese army until Japan surrendered. The American army captured the German soldiers and tried them by court-martial in China as war criminals. Because the German national government had surrendered, the Germans who continued to fight were violating the laws of war. The Germans argued that their courts-martial violated their Fifth Amendment due process rights. Their attorneys pointed out that the Fifth Amendment is not, by its terms, limited to American citizens. The amendment says that no person shall be put on trial for a felony unless he is first indicted by a grand jury, nor shall any person be deprived of life, liberty, or property without due process. After the Supreme Court heard the case, Justice Robert Jackson's majority opinion held that the Germans had no Fifth Amendment rights. Fifth Amendment rights for illegal combatants would lead to absurd results, Justice Jackson explained. First of all, the Fifth Amendment grand jury requirement has an express exception for cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. In other words, a soldier or active duty militiaman can be court-martialed even though he has not been indicted by a grand jury. If the Germans could invoke the Fifth Amendment, they would have the rights not enjoyed even by Americans in military service. Moreover, wrote Justice Jackson, if the Germans could invoke the Fifth Amendment, they could just as well invoke the Second Amendment and the rest of the Bill of Rights. This would lead to the ridiculous result of American soldiers, out of obedience to Second Amendment, being forbidden to disarm the army. And they go on to say, if the Fifth Amendment confers its rights on all the world except Americans engaged in defending it, the same must be true of the companion civil rights amendments, for none of them is limited by its express terms territorially or as to persons. Such a construction would mean that during military occupation, irreconcilable enemy elements, guerrilla fighters, and werewolves could require the American judiciary to assure them freedoms of speech, press, and assembly as in the First Amendment, right to bear arms as in the Second, security against unreasonable searches and seizures as in the Fourth, as well as rights to jury trial as in the Fifth and Sixth Amendments. They go on to explain how it's just a slippery slope. If they were to be given rights under American judiciary for First Amendment, then who's to say they want to go for the Second Amendment, including the gun prohibition lobby has long argued that the Second Amendment right of the people protects only the power of American state governments to have militias. This argument is not consistent with the court's opinion in Eisentrager. The irreconcilable enemy elements, guerrilla fighters, and werewolves in Justice Jackson's hypothetical are obviously not American state governments. They are individuals, and as individuals would have Second Amendment rights if the Second Amendment applied to non-Americans. Nor are the characters in Justice Jackson's hypothetical militia members. A militia is an organized force under government control. In contrast, guerrilla fighters or werewolves are individuals or small groups functioning in areas beyond the reach of any friendly government. The legal distinction between militia and guerrillas was well known during World War II. As Stephen Halbrook details in his book, Target Switzerland, the Swiss made extensive plans for their militia forces, consisting of almost the entire able-bodied adult male population, to resist a German invasion to the last man, but the Swiss government also warned its citizens not to engage in guerrilla warfare on their own. The militiamen fighting the Germans would be entitled to the protection of the rules of war and international conventions, but guerrillas would not. Having served as a judge on the Nuremberg trials, Justice Jackson was presumably familiar with the distinctions in the international laws of war between guerrilla fighters and soldiers and militia. Johnson and Eisentrager was, despite its unusual circumstances, a typical Supreme Court Second Amendment case. While the court has issued only a few opinions discussing the Second Amendment in detail, the court has written many opinions in which the Second Amendment is mentioned briefly, in order to make a point about something else, and in these mentions, the Second Amendment is overwhelmingly considered a right conferred upon individuals, not state-sponsored militias. So going back to this, Graham goes on, if anybody doubts there is a long-standing history in this country that your constitutional rights follow you wherever you go, but you don't have a constitutional right to turn on your own government, collaborate with the enemy of the nation, you'll be treated differently. What's the name of the case, if you can recall, that reaffirmed the concept that you could hold one of your own as an enemy combatant if they were engaged in terrorist activities in Afghanistan? Are you familiar with that case? Kavanaugh affirms with Hamdi. So she also linked something about Hamdi versus Rumsfeld, which is the case they're talking about here. A court of appeals determined that Hamdi petitioner, a U.S. citizen designated an enemy combatant, could be indefinitely confined and had no right to challenge his designation in federal court. Synopsis of the rule of law. The Constitution grants citizens held in the United States as an enemy combatant the right to a meaningful opportunity to challenge the factual basis for his detention before an impartial decision maker. Facts. Petitioner was an American citizen captured and designated an enemy combatant by the United States government. He was placed into indefinite confinement at Guantanamo Bay. Hamdi filed a federal writ of habeas corpus, and the Fourth Circuit Court of Appeals found his detention legally authorized and determined that petitioner was not entitled to further opportunities to challenge his enemy combatant designation. Petitioners petitioned, and the Supreme Court granted certiorari. Issue. Does the Constitution grant an American citizen held in the United States as an enemy combatant the due process right to challenge the factual basis for his detention before an impartial decision maker? And it was held by one judge, O'Connor J. Yes, the Constitution grants citizens held in the United States as an enemy combatant the right to a meaningful opportunity to challenge the factual basis for his detention before an impartial decision maker. Even in times of war, the country must retain its values and the privileges of citizenship. However, the exigencies of ongoing military conflict do allow, aside from certain fundamental elements, proceedings for enemy combatant citizens to be tailored to avoid extraordinary burdens on the executive branch. It may be necessary to rely on hearsay to support the designation as an enemy combatant. Such a hearing could even allow a presumption that the government's evidence is true, so long as the presumption is rebutable and a fair opportunity for rebuttal is allowed and still be constitutionally sound. Both parties agree that individual citizens initially captured on the battlefield are not entitled to their full constitutional rights at the time. This decision acknowledges the military's authority to prosecute war and grants wide discretion in the exercise of this authority, but also realizes that the courts must exercise their own constitutionally required roles in reviewing and resolving claims such as these. A state of war does not allow the president to act unchecked in the matters of the rights of American citizens, vacated and remanded. Dissent. Scalia J. If the rights of citizens are to be suspended during wartime, then it should be done so by the legislator, not by the courts. The plurality opinion limits the rights of citizens held as enemy combatants within the United States or its territories without acting by Congress. The Constitution allows Congress to take such steps. The courts should not be doing so. Petitioners should be released unless criminal proceedings are promptly brought or Congress suspends the writ of habeas corpus. Thomas J. The executive branch exercised its constitutional powers and, with congressional approval, determined petitioner to be an enemy combatant who must be detained. Such a detention falls within the war powers of the federal government and cannot be second-guessed by this court. Petitioner's challenge should fail and a lower court affirmed. Concurrence. The government has not shown, by Souter J., the government has not shown that the forced resolution allows for petitioner's detention, even if the relevant facts are as the government claims. If the government cannot claim evidence beyond the found in the record currently, the Non-Detention Act would require the petitioner be released. The branch of government whose role is to counter threats to the nation cannot be the same branch exclusively asked to strike a balance between defeating the enemy and safeguarding liberty in action taken to defeat that enemy. In these cases, the court attempts to balance two competing interests, respective for the separation of powers and the executive branch's efforts to protect the nation during a time of war, and the constitutional protections due to all citizens. This is a beautiful case that is going to be talked about a lot in the next couple years with all of these riots and all of the domestic terrorism that is going on inside our borders every day. I want to finish up this the rest of this case. Graham, okay, so the bottom line is, I want every American citizen to know you have constitutional rights, but you do not have a constitutional right to collaborate with the enemy. There's a body of law well developed long before 9/11 that understood the difference between basic criminal law and the law of armed conflict. And then he goes on to ask Kavanaugh if he understands those differences, which Kavanaugh says that he does. Okay, I just wanted to quickly show you guys all this and everything that's happening on this end, because I believe these two cases are going to be very important moving forward. I believe that what we're seeing, I mean, look at the foresight by Lindsey Graham to question Kavanaugh on the differences between the two bodies of law, being basic criminal law and the law of armed conflict. I guess if you think about it, there was a lot of riots and protests happening in 2014 and 2015. Happened after Trump was elected in 2017 as well. And then now it's on. I just believe we're living in a movie. I believe that when Trump went around the world in 2017 and he was like breaking the French president's hand and he was walking in front of the Queen and he was doing all these what seemed like disrespectful things. Now, 3 years later, and hindsight being 2020, pun intended, it's clear now why he was doing all those things. I have a feeling that he had called all of them up and was like, we know about you, we know what you're doing. Either you can play your role in this movie or you can be taken out. And there's a lot of stuff we don't know. There's a lot of conjecture. There's a lot of hearsay going on. I have faith. I have faith in God that we're moving in the right direction as humanity. So I just believe that, this is all growing pains. I believe we're kind of like a butterfly in a cocoon right now, and we're wriggling ourselves out. If that butterfly doesn't wriggle out of that cocoon, then they'll never have the strength in its wings to fly. Same with birds. So we're being reborn as a humanity, as a higher consciousness. And I think the power is in knowledge, and the power is in understanding the true history, understanding true law, understanding true science, understanding true math. And I believe we've been taught things that aren't true. And moving forward, I want to continue to make these videos because a well-educated, not an indoctrinated republic, but an educated republic is a safe republic, and a safe republic is an abundant republic. And I believe that's what we're moving into. So I just wanted to really, thank you so much for tuning in. If you like what you see, this is my first video. It's taken me a while to get to this point and to get the confidence to put one out, but I'm really excited to be in this fight. As a former military service member, I served under Obama and Hillary, and it wasn't what I signed up for. Let's just say that. And I'm grateful to have an opportunity to be a digital soldier in this shadow war. This is the war I signed up for that I didn't get a chance to fight. I got a chance to fight, but it wasn't what it ended up being, right? So I really appreciate you all. If you could like my channel, if you could subscribe, leave a comment. If there's anything that you would like me to cover, shoot it in the comments, and I really appreciate you. This is Ace with Conspiracy Realists signing off.